Good morning, everyone. Thank you so much for joining in early. And I'm happy to say at 10 a.m. sharp, we have about 74 students already in. Congratulations, everyone, for being able to join class really on time. So you guys really make me proud. So I'll begin. All right, so like any other classes, I like to do a recap to capture students' understanding on what was covered last class. Everyone, so thank you so much for participating. So let's begin with the case study. Everyone knows how to apply reading cases and statute for today's class. So we have Mr. Johan Abdullah, formerly known as K. Mutu, who is now a Muslim, converted all of his 6 children 3 weeks after he embraced Islam. So I'm pretty sure all of you found this story quite familiar, as I've come across in various newspapers for the past few years. Sharia court granted Mr. Johan Abdullah custody of 6 children after their conversion to Islam. So of course, the wife would not be happy, refused to accept the conversion of the children and seeking for your advice. So as lawyer, what you usually need to do is look through all the sources of law. So never mention to your client, okay, we can do this, and then you provide your answer based on common sense. So you need to always cite or support your answer with sources of law. So the sources of law in Malaysia, we have our federal constitution, which define law specifically to include written law, common law. So you can see here, operation of federation, even custom also you can support your answer, having force of law in federation in Malaysia. But in UK, because there's you've learned constitutional law, there's no written constitution itself, but still you can use sources of law such as the constitution itself, case law, legislation, treaties, convention to support your answer. So the number one reference that all lawyers need to do is usually the constitution, to find out what are the general rights available to any citizen. We call it the mother of all laws because any other legislation that's enacted will always ensure that it's within the umbrella of the constitution. So we have constitution, we have legislation. Some students will come across other terminologies such as statutes, such as act. These are all means the same thing. It's a legislation. This is where all key information pertaining to crimes or any areas relating to contract or any other areas of law, or how this behavior is going to be conducted, all will follow the legislation or the statute or the act. So we also have common law. We also have rules of equity. Common law essentially are cases. These are the ones where you want to search for precedent, just like how your classmates have mentioned earlier. So you make reference to other cases that was previously decided to support your answer. But my role here to teach how do you choose which case for your answer. You have judicial decision, you have Islamic law in Malaysia and some countries as well. And there's also a custom and also usage. Please remember in UK, there is no written constitution. They are supported with various types of statutes to compile on the rights of the citizen in England and Wales. So this is what Malaysian constitution looks like. In UK, there is none. In some other countries for international students, so you have to check if there's written or unwritten constitution for your respective countries. But in Malaysia, it looks something like this. So you have the emblem, it's written there, federal constitution, and on the subsequent pages, you can see the arrangement of the wording here would be, I'll just highlight it here, articles. So under constitution, they don't use section 1, section 2, section 3. So if you want to support your answer in any subject, if you make reference to constitution, it should be article 1, mention this, this, this. Article 2, mention this, this, this. So if you can see the word article will be repetitive in each section itself. So this is how the moment you see Article 1, you already know that particular person is making reference to Constitution. But in UK, there is no written Constitution. So in UK, so how do you support your answers or arguments in order to act on behalf of your specific clients? So you have legislation or statute. Legislation or statute would be the one that's passed by the Parliament itself, the Westminster Parliament. This would be covered in the topic of English legal system, as well as constitutional law. And whatever that has been passed will be applied throughout UK itself. But this part here actually only applies to Malaysia, because in England and Wales, they do not have state assemblies. So I should replace here English and Malaysian law. If you have a note in front of you, you can type here only apply in Malaysia, because in Malaysia, we have our parliament, we also have state assemblies. The role of state assemblies is to govern matters pertaining to state, whereas the parliament will govern matters that concerns the entire nation. Whereas in UK, they only have Westminster Parliament that will pass bill and applies throughout UK. You will learn on the topic of devolution, where certain powers will be delegated to certain country. So it is only up to that in terms of the powers of creating laws. You also have here cases and common law. These are the ones that judges will pass judgment, and usually you will find the legal reasoning in the judgment itself to support your point in a particular area. So between statute and cases, if there is a conflict, which one will prevail? If there's any conflict, let's say legislation said something else, and judges provide judgment on, provide a contrary decision to the legislation, legislation will always prevail. So if there's any conflict, you always remember the laws that was passed by the parliament will always have higher authority as compared to cases or judgment provided by judges. Because you remember, any laws that created by parliament will go through a stringent process. It will start from House of Commons, and it's not even, passed by one person. You're talking about the members of parliament, like hundreds of them, and then it goes through House of Commons before finally receive royal assent. So because of the detailed scrutinization, very stringent processes, so that's why legislation always prevail. Whereas cases are developed by judges, sometimes it can be written by a single judge, so you only have thoughts by one judge. Or sometimes it can be made a decision by 5 judges. So as compared to laws created by parliament, where it involves deliberation between hundreds individuals, as opposed to 5 judges, of course, legislation will always prevail. So in any of your answer, if you have a legislation, first of all, you start writing your essay by identifying which legislation that applies to your current situation. Contracts Act, for example, Criminal Code, for example, anything with legislation first. And after that, how do you determine Section 2 is applicable or relevant to your client situation? That's where you find other common law cases to say that this case applied Section 2. Therefore, in your client's case, you're going to apply Section 2 as well. So that's how it works. Okay, so we have other types of sources that you can make reference. For example, Halsbury Laws of England. Usually these are the ones that provide ease access of references for lawyers. So if they want to find Section 2 has been applied by how many cases, so you can go to Halsbury Laws of England, you click on Section 2, then all the cases that cited Section 2 will be there. So it's good if you can familiarize yourself on how to use Halsbury Laws of England and Wales. Hansard, sometimes students want to determine why Section 2 or Section 10 is important, whether or not, because certain acts was enacted in 1800, right? Whether or not it's still applicable in 2021. So to determine what's the reason behind passing a certain legislation, you make reference to Hansard. So this is this is how people or the society can distinguish between excellent lawyer as compared to average lawyer. So excellent lawyers will do additional extra research to find a special answer to support his or her client's case. You have law commission reports. These are the ones where sometimes you want to make certain changes towards the legislation. In UK, we have the Land Registration Act, because land law in UK is very steep in history since 1066. So how do you change the law that was developed in those days and in modern days? So law commissions will do investigation. They will have a committee, then they will produce like a very thick report. All of this you will embark in year 2. You have law journals as well as textbooks. So if you see lecture notes is not there, so please do not cite lectures note to support your answer, either in presentation or in any written assignment or in the exam itself. So what does legislation or statute or act looks like? So just to emphasize to everyone, when you want to make reference to an act, it always starts with capital A. Either you make reference in the beginning of your sentence or at the end of the sentence. Act always starts with capital A. Capital A, act, symbolizes legislation, whereas small a, act, signifies an action or behavior. So if you do Land Legislation Act, then you will see examiner will circle your act because it's not the proper spelling. So this is what statute look like in UK. So you have the emblem here, and this is the first page. You see the title here, and you can see here they are separated into different parts. But when you want to make a reference for a statute or legislation, so if you have a pen or paper or Word doc, when you refer it, you call it like section 1 or section 2 or section 3. So it's not article. Article is only reserved for constitution, and section would be for legislation, statute, or act. So this is the close-up. So you can see more information. You have the long title, what's Land Registration Act is about. You have the preamble, which means the opening statement by the Crown, and a detailed provision for each particular section itself. So you have section 1. If you have here, how do you pronounce it? So if you have bracket 1, so if you want to make reference to this provision, so you say section 1, sub 1 of Land Registration Act 2002. So this is crucial during your video presentation. Some students will say section 1, bracket 1, then when I mark, I'm like, nah, it should be section 1, subsection 1. Okay, it's bracket 1. Even if you write an essay, it should be 1, bracket 1, and not 1.1. This is very crucial because this is how lawyers actually write in their submission. So if you want to do internship, you have to follow this format. Okay, so just now I mentioned, right, with regards to the case, students said must refer to precedent, must do legal research. So how do you begin? Of course, first one would be the legislation, and then you need cases to support your answer. So if it's English cases, you look at the hierarchy of courts. So you have, this is the UK Supreme Court. We look here, you have UK Supreme Court as the highest court of law in the UK itself. So we make reference to England and Wales. And then after that, it followed by Court of Appeal, you followed by High Court. And if you have criminal cases, you can make reference to Crown Court, civil cases, County Court, and you can also have magistrate courts, a judgment from decision from magistrate courts, or some cases would be tribunals. So I'm just going to ask this question. If let's say you're doing internship and you found 10 cases to support Mr. Johan Abdullah, 10 high court cases, and you have one student who managed to find one UK Supreme Court decision, which lawyer, in your opinion, will take from which student? So I was student A. So when I did internship, I was so proud of my research because I found 10 High Court cases. And then the lawyer said, shred it all. He doesn't want to use High Court cases. So imagine how many cases that I've printed, I have to shred all of them, because between High Court and Supreme Court will have higher authority. No matter how many hundreds of High Court cases, it will not be applicable. You must make reference to Supreme Court case. You only need one Supreme Court case. And I've also made a crucial mistake when I found a case, Court of Appeal. I was so proud of it. Okay, it's better than 10 High Court cases, right? So I've used Court of Appeal. And then you know what happened? We went to court and then the case got thrown off because of my bad research. Because that case, Court of Appeal, there's also another case, a Supreme Court case, which has overruled the Court of Appeal case. So as a student, if you want to use any cases from High Court or Court of Appeal, you have to be very diligent to make sure that these cases do not have higher courts overrule your decision. Always start your research by searching the Supreme Court cases in UK. If it's in Malaysia, it's a federal court case. So this is the hierarchy of courts in Malaysia, because at Taylor's you learn dual jurisdiction, English law as well as Malaysian law. So for Malaysian component, the highest court in Malaysia would be federal court, followed by Court of Appeal, and you have High Court, but it's separated into High Court of Malaya and High Court of Sabah and Sarawak. But either way, if you come across of High Court cases, if it's in Malaya or Sabah, Sarawak, it's all the same level. You can cite both cases, and followed by the rest of the lower court. So in UK itself, if you want to make sure that this one particular case are binding on the lower courts, you always refer to the High Court first. So I put down here, you have Supreme Court, Court of Appeal, High Court, Criminal Court or County Court, and lastly, Magistrate Courts. The one that is usually binding on lower courts, the decision will be Supreme Court, Court of Appeal, and High Court. These are the one. Whereas for Malaysian court hierarchy, the highest one will be Federal Court, followed by Court of Appeal, High Court, and lower courts. So the decision on point of law, especially on the legal principles, whatever you do, if you want to cite it, you always cite Supreme Court cases. But sometimes you have a decision of Supreme Court in 2010 and Supreme Court in 2020, and the decision differs. So which one you follow? You have 2010, which says one point, and 2020, you says a different point. So if there's conflict, which one will prevail? So it's because the latest version can overrule the old one. So even though it's both at Supreme Court level, so you have student A, which is me, who cite Supreme Court 2010, and then you have a student B who cite Supreme Court 2020. The one that will get praise will be the student B that cites Supreme Court 2020 version, because Supreme Court 2010 has been made obsolete, no longer relevant, even though it's at the highest authority. Always take the latest one. So if you come across various Supreme Court decision, so you have to make sure whether Supreme Court support each other decision or one decision has overruled the other decision. So if it has overruled, you can never cite it. It will become very crucial for your client. It can make the whole argument collapse because you've cited the wrong Supreme Court case. So just now we have a scenario one with regards to Mr. Johan Abdullah, and it's actually based on a true story. So I put down here an example of Indra Ghani's case, and I put bracket at the end. That's where you know it's a Malaysian case and it's at the highest level federal court case. So the issue is whether the mother and father of a child from civil marriage, which is not on Sharia law, must consent to convert the child in respect to that particular child. Because the issue arises whether you need both parents, father and mother, or one unilateral consent sufficient. So this matter was brought all the way up to the federal court. So because it concerns conversion, it has involved Sharia court. So Sharia court upheld the conversion of the children. So it means the children remain to be as a Muslim. It was converted by the father. So that's why you can see the name of the appellant here Indira Gandhi would be the mother. So this is a federal court case. So when you want to refer the name of the parties, right, the one that's highlighted in yellow, you will come across in a judgment, it keeps make reference to the appellant. So if it make reference to the appellant, that's where you know this is an appeal case. But if you come across judgment which says plaintiff, 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 that's where you know it is a case at the first court of first instance, which means that's where the trial first begins. You have plaintiff and defendant. So if it went to the Court of Appeal or federal court, they no longer use the term plaintiff or defendant. You make reference to appellant, which is Indira Gandhi, and the respondent. So you can see the name of the respondents here. Okay, so High Court set aside Sharia court decision. Sharia court upheld the conversion. So that's why the issue went to federal court, because you need to determine which court that should hear this matter relating to the conversion of children. Should it be High Court or should it be Sharia court? So Court of Appeal upheld the conversion. And lastly, federal court reversed the decision. Reverse means you have to revert back to the original religion that of the children first. So which means it will be Hinduism. Upheld, which means the decision of the High Court has been sustained. If it's reversed, you follow the decision of the federal court case, where federal court can reverse the decision of the lower courts. Of course, this case has attracted a lot of attention because it concerns of conversion. Here, it has drawn a line and a debate whether Muslim parents can convert a child without the consent of another parent. So here, the issue arises without the consent of their Muslim spouse. So as a lawyer, so you need to define what's the term parent. So parent, does it mean father or mother? Or parent, does it mean both? For future lawyers, for all of you, whenever you want to provide answer, you must cross-refer either to the Constitution, legislation, or cases. So Kevin made a reference to the Constitution, which is absolutely correct, because in the Constitution, this provide included the parent can decide on the religion of the children, but then you need to determine, because the word parent is without S. So does it mean singular, one parent, or does it mean parent means parents both? So that's why I've highlighted here the word parent, because you need to determine if it's one parent, another issue, if it's father or mother, or both parents. So in Malaysia, we have Interpretation Acts 1948 and 1967. You can use this act now in year 1, year 2, year 3, even when you practice as a lawyer. Any interpretation, you always make reference to this act first. But if certain words, like such as Bitcoin, because it's a latest term used, if it's not covered here, then you make reference to common law cases. So if you look at section 4 of the Interpretation Act, subsection 2, which says that any words or expression importing masculine gender, because just now mentioned his, right, include females as well. So this is where you know, even if the child is a female, the Constitution also applies, must get consent from parent. Covering on how to read an enactment. Whenever there is an enactment, so you're probably wondering what's the differences between legislation and enactment. So legislation are laws passed by the parliament, whereas enactment are laws passed by the state legislative assembly. So each state, they govern their state matters. So if they want to pass certain laws with respect to particular state, so that's where it's called enactment. So if you can see here, the emblem says Negeri Perak. So the enactment only applies in Perak itself. So I highlight here based on state, and you have enactment number 4. So if you want to know what this act is all about, so more information is provided under the long title and preamble. So whether it governs the conversion or administration of the religion or what else. Okay, so this is how you read the enactment. This is the short title. So you have Administration of Religion of Islam (Perak) Enactment. And this enactment deals with making new provision on the administration of Islam religion, establishment of the Islamic Council, and the Perak Malay custom. So anything deals with custom, anything deals with the role of Islamic Council in Perak would falls under this enactment. So how do you read legislation? So because there are thousands of legislation, there's thousands of statutes or even act. So usually the first point that you refer to is the name of the legislation itself. So I put here arrow, which means this is the short title of the act, a quick reference on what this act is. But if you want to know exactly what this act is about, it's usually in the long title of the act, which states that this is an act that deals only with the guardianship of the child. Arrow, be enacted, all of these are the preamble. Preamble means the opening statement by the ruler. In Malaysia, is by the Agong, it's here by the monarch. And you have this one is the date where it has received royal assent. So royal assent means the monarch gives green light that the bill can become an act. If you can see short title, even this section also generous enough to say that the short title is this. So if it comes out in your exam, you already know it's this. And you can see in terms of the application of this act, it says that this act shall apply to the state of Peninsular Malaysia only. So which means Sabah and Sarawak, this act does not apply. So it's very crucial for any act that you want to refer to, you refer for the first 3 sections. Section 1 talks about the act, the name of the act. Section 2 usually talks about the application of the act, and the section 3 probably talks about the definition of the act. So that's why if you want to define the word parent, you go to the Constitution. If Constitution make no reference whether parent includes mother or father or both, you must look at the legislation. And if the legislation make no reference, then you go to common law cases. So there is a proper hierarchy for lawyers or law students to make reference. This is when you want to read UK legislation, you can see the format is the same. So you have Sexual Offences Act, the short title. This one is just the chapter number. This is the long title, date of royal assent and section. Okay, so this would be here. I put subsection. You have to put subsection 1. So if there is another sub here, you don't refer to section 1, subsection 1, subsection A. So you can say section 1, subsection 1, paragraph A. So this is where just now with regards to the Indra Ghani's case, the issue whether unilateral conversion, the converted father is sufficient. So you need to interpret the word parent, right? So this is where I've extracted the excerpt of Federal Constitution itself. You look at Article 12, sub 4, which says that the religion of a parent under the age of 18 shall be decided by his parent. So you have his parent, which means the son's parent or the son's daughter parent, children, or only one gender. So how do you interpret this? So this is where you need to make reference to the Interpretation Act. So how do you define his? How do you define parent? We look in terms of how cases are cited. So you have civil cases. Civil cases means cases that usually involve 2 individuals, 2 parties. You can see here Carlisle is 1, and you have Carbolic Small Ball, another person. So it can be individual or a company. Whereas criminal case usually involves an individual and the state. So that's why you have R here. So it cannot be Carlisle and Roberts. If it's 2 individuals, means it's a civil case. If it's criminal case, then it usually involves the state. So you have the names of the parties, you have year, usually you need to bracket it. This one here, remember when we cited, we learned about citation last week. This, the first number after the year, is the volume number, because this journal, QB, the Queen's Bench Journal, got thousands of journals. So you need to know which journal that you're going to use. And this one is the first page of the number where the case appears in that journal. Same goes for the criminal cases. So that's how you cite criminal cases or even civil case. So these are other types of cases. Sometimes you can have as short as R against Smith. Sometimes you have RE-P, bracket recognition of registration orders. You have R and Secretary of the State. You even have CR and United Kingdom. Sometimes you can have R and S. So why can't the court include the full name of the parties? So sometimes if involved, it concerns a minor, children. So you do not want to reveal the name of a child. Actually, you can't reveal the name of a children. So that's why they just put initial R and S. Same goes as CR. So there's always a particular reason that you want to protect the identity of the individual. There's also a case involving a soldier where the surgeon supposed to amputate the knee, but for some reason mixed up in the operation theater, the surgeon actually amputated his private parts. So he wants to take an action against the surgeon and the hospital. So you don't want to reveal the name of a soldier because it can be embarrassing for the soldier. So that's why you put the initials of the name of the patient. These are the examples of law reports. There are thousands of law reports out there. So you don't have to memorize all this. When it comes to referencing, you can put initial AC, MLR to cite the particular case. You can also put the full name. So there is no wrong answer when it comes to citation with regards to law reports or the name of the journal itself. Okay, so these are the judicial titles, the name of the judges. Students will be tested during their video presentation. When they want to cite a name of a particular judge, you should say Lord Chief Justice followed by the name, not LCJ followed by the name. Then we know that students do not know to make proper reference. So you can have Lord Justices, Master of Rolls. In Malaysia, the Chief Justice in Malaysia itself would be Chief Justice of the Federal Court, followed by the President of Appellate Court and the rest. And this is with regards to the citation on how to read a particular judgment. I'm just going to go through quickly because we have an activity later after this class. So how to read cases. Number one is always identify which court that you're referring to. It must be Federal Court. If cannot, then you go to Court of Appeal and High Court. You must read the facts of the case, not just the summary, to have a feel on what's happening. So as a good lawyer, that's where you're able to pick it up, each word that was used in the judgment. Is it parent or parents? Is it his or her, or is it both? So all of that. And also remedy sought. Some parties, they want damages. Some parties, they want the original situation to be reinstituted to the original position. That's what we call restitution. Some do not want money at all. They just want compel someone from doing something. Like if you own a business, you want the supplier to continue supplying so you can get a specific performance. If it's sexual harassment cases, you want someone to stop doing something, then you can ask for injunction. So you need to identify which are the remedies sought by the parties. Prior proceeding, you need to determine whether or not the case have been deliberated before, points of the parties, grounds of appeal. With regards to just now conversion, right? We talk about unilateral conversion, whether or not it's sufficient, issues, outcome, and you also have ratio decidendi, which means the legal reasoning or legal principle behind that particular decision. So it refers to other things that the judges said, but not necessary decision which was made. So this is how you read particular cases. So all of you will be tested on this point in your legal writing assignment as well. So this is how you read particular cases. So all of you will be tested on this point in your legal writing assignment as well. Okay, so this is the end of this chapter on reading cases and statutes. Till then, I'll see you guys next week. Bye.
Thanks, Miss.
Thank you, Miss.
Thank you.
Thank you so
Thank
much,
you,
Miss.
Miss.
Bye.
Thank you, Miss.